We will now be discussing 160, 161, 162, 163, 164, 164A. So 160 is you can be asked to be present before the police station to give information about a particular crime which the police believes that you have. So 161 is the examination of witness by police. It provides for oral examination of a person by investigating officer when he is acquainted with the facts of the case and circumstances of the case. The purpose for and the manner in which the police statement recorded is given under 161 and it can be used at any trial as indicated in 162 CRPC. Now let's see 161. The object and purpose of section 161 is to collect evidence regarding commission of an offence by examining and recording the statements of witnesses, material in respect of the commission of the offence. Signing of the statement under 162 is prohibited. At 161 statement should not be signed as per 162. It is the prerogative of the police officer to record the statement of a witness examined. Now why is it done so? Because they want the police officer to be given 100% free hand to note down and pick and choose and write down what all the things that they think are relevant to the investigation, not to be bothered by unnecessary details if you view it positively. If you view it negatively, it means they don't have any faith on the police officer writing down everything verbatim as told by the witness. The two meanings will come for it. Any police officer making an investigation on this chapter, acting on requisition of such office, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. There are two things you have to note. One is any person. Second, this person is acquainted with the facts and circumstances of the case. Now next, the police will ask, you yourselves are saying the judge has no faith on police. So then why should I answer? You can always say no, I will not answer. But the law makes it compulsory. It says such a person whom the police asks a question shall be bound to answer truly. What are you bound to? You are bound to answer truly all the questions, no gaps, relating to such a case put to him by officer, other than the questions to which there is a tendency to implicate yourself to a penalty or forfeiture. The police officer may reduce to writing any statement made to him in the examination. He shall make a separate and true record of statement of such person whose statement he records. He can make two. Statement made under this subsection may also be recorded by audio, video, electronic means. Statement of a woman against woman offence under section 354, 354A, 354B, 354C, 354D, 376, 376A, 376B, 376C, 376D, 376E or 509 of the IPC is alleged to have been committed, all women-related offences, shall be recorded by a woman police officer or by any woman officer. If a police officer is not there, some woman officer, government official. Civilized people are generally insensitive when a crime is committed, even in their presence. They withdraw both from the victim and the vigilante. They keep themselves away from the court unless it is inevitable. This is what stated by court in Appabhai versus State of Gujarat, 1988, Supreme Court. Because you could not produce independent witnesses in that particular case. In the process of investigation, 161, any police officer making investigation is accredited, empowered to examine orally any person acquainted with the facts and circumstances and to record statement of such witness. These are called 161 CRPC statements. Remember this number, 161 CRPC statement. The aim is to gather evidence against the accused. After filing of charge sheet, these statements will be perused by the court to take cognizance of an offence. Such a statement can only be utilized for contradicting the witness as provided under 145 of evidence. Statement of witnesses recorded under 162 during investigation cannot be used for corroboration or assurance of a testimony of a witness in court. If the statements recorded by the police, it could be only for contradicting the prosecution witness. What is the purpose of 161 statement? That the witness will again come in the court into the witness box and he will be asked by the judge to narrate everything from A to Z if he comes as a prosecution witness, without any gaps and without any editing on his own part. And then when you are cross-examining such prosecution witness, after he has given all his statement, you can use this statement, 161 statement given to police, to contradict him if he gives any statement which is at variance from what it is recorded in the 161 statement. But they cannot be used for corroboration, they can be used only for contradiction. Next, 162. Statement to police not to be signed. Use of statements in evidence. No statement made by any person to a police officer during an investigation and shall be, if reduced to writing, signed by the person making it, nor shall any such statement, whether in police diary or otherwise, be used for any purpose at any inquiry or trial in respect of any offence under investigation. So what is this? I said it cannot be used for any other purpose, for any purpose whatsoever. So why is it saying so? Because it is giving free hand to the court to arrive at the real issues, the real events in the court itself, without depending on a secondary material that is given by the police, because finally it is the court that is to give the punishment. When any witness is called for prosecution in inquiry or a trial whose statement has been reduced into writing as by police in earlier, if duly proved, may be used by the accused with the permission of the court to contradict such witness in the manner of 145 Indian Evidence Act, cross-examination. When any part of such statement is so used, any part thereof may also be used in re-examination, but the purpose of explaining any matter given in a cross-examination. Nothing in this section shall be deemed to apply to any statement falling under provisions of Indian Evidence Act to affect provisions of section 27 of that act. Omission means an omission to state a fact or a circumstance may amount to contradiction if the same appears to be significant or otherwise relevant having regard to the context in which omission occurs. Whether any omission amounts to contradiction in the particular context shall be a question of fact. It depends on the case. Next, 163. No police officer can offer any inducement. Now, let us see what is a contradiction. Now, here we have now understood that 161 statement, the importance of 161 statement is especially to the accused. It is especially to the accused to find out loopholes in the statement of the witness in the court, in the witness box, basing on the 161 statement given to the police. That is what we call as contradiction. Now let us see what is contradiction. In case of a witness testifies before a court that a certain fact existed without stating the same before the police. It is a case of conflict between the testimony before a court and the statement before the police. This divergence of testimonies in the court and police is called the contradiction. That is, one is going to north, another is going to south. Therefore, statement before the police can be used to contradict his testimony. Let's see the case Appa Bhai versus State of Gujarat. Court observed, the court, while appreciating the evidence, must not attach undue importance to minor discrepancies. The discrepancies which do not shake the basic version of prosecution case may be disregarded. This is contradiction. And the limitation on this contradiction is, don't try to find ticks and dots. He has not dotted the I, he has not ticked the T. That's not important. What is important is, on the overall basis, on a gross basis, whether the facts as given in the court tally or do not tally, or at variance or contradict the statement recorded by the police. That's the main thing. It's on the gross basis. Only then it will be of use, not the finer ticks of and dots. Now next is omission. Supposing one part of one section of contradiction is omission. That means contradiction is, I say A killed, then later on I say B killed. That is contradiction. But supposing I completely ignore that while A was killing, B was supplying the weapon. I don't talk about B supplying the weapon to A to kill. Now that is called omission. So it can be a skip or a slip. So it is called exclusion or leaving out. If a certain fact is testified by a witness in his examination in chief, which is testified in court, it is omitted before the statement in police. It is called omission. Now, it is to be tested by the court whether it is a material omission or not. So there can be any number of immaterial omissions. There can be any number of details that are omitted. But it should not be a material omission. The main issue should not be omitted. If it is omitted, if the material omission is there, it amounts to material contradiction. Relevant and material omissions amount to vital contradictions. That is the main thing that has to be brought out about by the cross-examination by the defense, which can be established by cross-examination. This is said in case of Tahsildar Singh versus State of UP. If you have any time, I request you to please download this Tahsildar Singh versus State of UP 1959 and read the entire thing, because Tahsildar Singh is a very, very famous and very, very important murder case, where Supreme Court has dealt with in detail about all this procedure, CRPC procedure. And in the case of Ponuswamy Chetty versus Emperor, bare omission cannot be a contradiction. That light is there or not. Okay, you are running on the right side, you are sitting on the left side. Okay, he came from the right, he came from the left. So small omissions can be allowed. The rules of evidence in 145, 154 and 157 are of paramount importance. Contradictions in the previous statement in writing of a witness is a very powerful weapon in the hands of the adverse party, that is the accused. A contradiction may be such as to demolish the case made out in the examination in chief. In a criminal trial, the level of proof has to be beyond all reasonable doubt. So statement of witnesses recorded under 161, copies are also given to accused. These can be used by the accused for proving contradictions. Contradiction is very, very important. During investigation, police record statements, 161 statements. The purpose is to gather evidence and preserve it up to trial. While police file charge sheet, they supply copies of 161 statement under 207 CRPC to the accused party, defense. On filing charge sheet and seeing the contents and 161 statements, then the magistrate will take cognizance against the accused. Because the charge sheet is not filing charges, remember. These two things is a normal confusion, lot of confusion is there. One word is charge sheet, that is filed by the police. The second is framing of charges, that is done by the magistrate. And then the cases come for trial, 2 sessions in CRPC, criminal, major. So these two are different things. Framing of charges is the judicial activity, right? Filing of charge sheet is an investigative activity of the police. These two are completely different. Remember that. After accused put in trial on framing of charges, when a defense can use 161 statements to test the truthfulness of statements as it provided under 145. Now, if this is the case, then the first question we will get is how to record contradictions in evidence. The portion of statement which is about to use for contradiction first brought to the notice of witness and should be questioned about it. If the witness admits that he made such statement before police, then no further proof is needed. But if the witness says that he made contradicting statements under pressure from police, comes the role of contradiction, then the court is bound to note such statements and give an exhibit number. By that process, contradiction merely brought on record, but those are subject to proof. It is said to be proved if the investigating officer who recorded the statement is confronted with the statement as to whether witness made that statement and why did you write it down later. If he gives affirmative answer, then the said contradiction is said to be proved. If the IO says, he said like that, but I understood like that, therefore I wrote like this, then it means it is proved. In the case Syed Hussain versus State, correct way and proper way of proving a contradiction or omission is to ask the IO about it in his evidence. Normally, remember, eyewitness is examined first, IO is examined last. Get the idea? Eyewitness is examined first, and the person who is giving a complaint is examined early on, and the IO, sub inspector or CI, or DSP, he is examined last at the end of everybody. So we have to put it before him that this man, evidence that came before you, he told us like this, you have written your statement like this. Now what is the difference between the two? Why is the difference? Please explain. So then you can ask whether a certain statement was made before him by that witness. If that procedure is not adopted, it cannot be said that there was a proof of the statement by the witness. The trial judge has to decide in each case after comparing parts of the statement recorded by police with that made by the witness in the witness box, and to give a ruling having regard to the aforesaid principles whether recital intended to be used for contradiction satisfies the requirement of law. Now, Rule 29, Chapter 6 of Criminal Manual. When a statement recorded under 161 CRPC is used in a manner indicated in 162, the passage which has been specifically put to witness in order to contradict him should first be marked for identification, then exhibited after it is proved. Remember, two things will be happen. One, if it is if the contradiction comes out, then you ask the court to mark it. And then when you put it to the IO and he says yes, he said so, then it is exhibited after it is proved. Then it becomes an exhibit. Then the method of proving such statement is to question the police officer who recorded the statement whether the passage is a true extract. When a statement under 161 is used to contradict a witness, specific statement put to witness should be set out accurately in the record of deposition. Omissions in statements under 161, if denied by witness, be proved by questioning the police officer whether a witness had really made that statement when you asked him. On point of appreciation of evidence, Supreme Court said in case Ganesh K. Gulve versus State of Maharashtra, in order to appreciate the evidence, the court is required to bear in mind the setup and environment in which the crime is committed, the level of understanding of the witness, the over jealousness of the near relations, everyone's different way of narration of the same facts. They are only illustrative. Broad principles are: evidence is required to be appreciated to find out what part of the evidence represents a true and correct state of affairs. Underline this word. The evidence should be a representation of true and correct state of affairs. It is for the court to separate grain from chaff. In respecting the recording contradictions, the trial court are required to carefully read the provisions of 162 and relevant provisions of 145, 155 and 157 of Indian Evidence Act. Now, what is the evidentiary value of such contradictions and omissions? The statement of witnesses recorded by police officers during investigation cannot be used as substantial evidence. Already told you, 161 statement is not substantial evidence. It cannot be used for any purpose except for the purpose of contradiction, as under Section 145 Indian Evidence Act. Where any part of such statement is used, any part thereof may also be used in examination for the limited purpose of explaining any matter referred to in cross-examination. The only other exception to this embargo is when the statement comes under purview of Section 32(1) or 27 of Indian Evidence Act. That we'll discuss later. The bar created 162 has no application in the proceedings under 32 and 227 of Constitution or in civil proceedings, and a statement made before the police officer during investigation can be used as evidence in such proceedings. Now, it was laid down in Punya Sankola versus Balwadra, 1985. The expression investigation under 162 means Chapter 14 of CRPC, where 162 occurs. The language of Section 162 is plain and explicit. It admits of no doubt. 162 says restricted use of such statements, prohibiting the court from using them as corroborative of statements in court. Now let us see the opposite. Supposing if the court is allowed and the police is allowed to take signature of the party and court is allowed to treat it as the substantial evidence, then there is no need for trial in a court. You can just take the documents, all the signed statements given to the police, and based on that pass the judgment. You don't have to bring the witness before you, bring the accused before you, bring the eyewitness before you, ask them, question them, observe them, analyze them, and then give opportunity for both the prosecution and the defense to examine and things like that. So, the reasons for prohibition of use of statement made before police during the course of investigation is the purpose of corroboration is that police cannot be trusted for recording the statement correctly, as they are often taken down in an undeterminate manner in the midst of confusion. Because when police enter the scene, everything is a very big confusion. There is no clarity. But when it comes to trial, the entire confusion has been neatly stacked out in different columns, and then it is set down in a particular order for the court to take an opinion. So, because when you are writing something in confusion, you tend to either exaggerate, over exaggerate, or overplay or underplay. If there is just a assault, you may say it is murder, attempt to murder, or if it is an attempt to murder, you may say it is only assault, because it is all in the midst of confusion. At the time, very close to the time when things are happening, maybe crime is in the process also. So in such cases, there is a lot of confusion. So bring statements within the ambit of 162, it must nearly not be made during the period of investigation, but must be made in the course of investigation. Not during the period, but also in course. What is the difference? Supposing investigation is made from 1st January to 31st March. Okay. But the investigation, that's the period, 90 days is the period. But the investigation actually, when the IO went for investigating or went out and talked to the people, etc., is only on date 10, 15, 20 only. So that is on 10, 15 and 20, not just January to March. The 10, 15 and 20, that statement should be made. The words during imply that the statement must be made as a step in a pending investigation. The two things at the period of investigation and course of investigation are not synonymous. We tend to take them to be synonymous. Statement must be ascribable to the inquiry conducted by IO or any other officer, not one which is de-horse. So the other statement, though made at the time of investigation, during investigation, is not hit by the probability of 162. Therefore, such a statement can be used for corroborating and contradicting purpose as per 157 and 145. Another case we see here, Baleshwar Rai versus State of Bihar. It was held that 162 CRPC only bars proof of statements made to IO during course of investigation. 162 does not say that every statement made during the period of investigation is barred. For a statement to come within the purview of 162 must not merely be made during the period but also during investigation. Period of investigation, course of investigation are not synonymous. Okay, 162 is aimed at making statements recorded by police officer while investigating during the period. Okay, they speak only of statements made to police officer during course of investigation. Statements ought to be excluded from evidence must be ascribable to the inquiry conducted by the IO and not one which is de-horse the inquiry. Communication like some exhibits or letters, some books, some records that came into the control of the police, they will not fall under the ambit of such statements. You cannot say they cannot be used. Okay, let us say we say there is a suicide case and there a diary is recovered. We cannot say this is the statement made to the police, so you cannot use it. Get the idea? So in Raghunandan versus State of AP, that the bar imposed on 162 CRPC is not explicit or specific enough to extend prohibition of the use of the wide and special power of the court to question a witness, expressly or explicitly given by Section 165 Evidence Act. 162 does not impair the powers of the court. Now, if there is an inconsistency in evidence, it is not sufficient to impair the credit of the witness. No doubt, 155 Act provides a scope for impeaching credit of the witness by proof of inconsistent statement. But all inconsistent statements are not sufficient to impeach the credit. A former statement, though seemingly inconsistent with evidence, need not be sufficient amount to contradiction. In Appabhai versus Gujarat, Apex Court said the court, while appreciating evidence, must not attach undue importance to minor discrepancies. The discrepancies which do not shake the basic version of the prosecution, they are to be discarded. Discrepancies do not shake the basic version, may be discarded. Discrepancies which are due to normal error of perception or observation should not be given importance. Error due to lapse of memory may be given due allowance. The court may call into aid its vast experience of men and matters to evaluate the entire material on record by excluding exaggerations. When a doubt arises in respect of certain facts, proper course is to ignore the fact only, unless it goes to the root of the matter to demolish the entire prosecution story. The witness these days go on adding embellishments to their version for fear of their testimony being rejected by the court. Nowadays, because of the TV effect, every witness who comes into the witness box gets an audience all of a sudden. So he is on a hyper mode. So he tries to add as much verbosity, as much of detail as he can imagine into a very simple action that happened in the crime scene. Because he wants to take the center stage in the witness box for a longer period of time. So he may add so many details which may not be there in the original statement which was given in the police station or even in the situation itself. So the court should not disbelieve the evidence such witness altogether if they are otherwise trustworthy. If in the gross part of it, if the fact part of it is correct, then embellishments you forget about them. In Arjun versus State of Rajasthan, court said a little bit of discrepancy or improvement do not necessarily demolish the testimony. Trivial discrepancy should be ignored. The usual character of human testimony is substantially true. Similarly, innocuous omission is also inconsequential. Evidentiary value of 161 statement if signed by the witness. Basically, the signature of witness on 161 is not necessary. Practice of getting signature of 161 is prohibited under 162. The violation may sometimes diminish the value of testimony when they come to court. However, it is not the law, there is nowhere it is written that if there is a sign, if the person insists on signing and if he signs, then there is no law that it should be ignored. In such a situation, the court must be cautious in appreciating the evidence and the witness who gave signed a statement given in court. You have to compare and contrast and arrive at the truth. In the case State of UP versus MK Anthony and Rajasthan versus Tejaram, 162 CRPC does not provide that evidence of a witness given in a court becomes inadmissible if the statement given to police is signed. Nowhere it is written. It merely puts the court on caution and may necessitate in-depth scrutiny of the evidence, that's all. Next, what happens if there is a delay in recording 161 statements? Delay in recording statement of witness does not necessarily discredit their testimony. If there are credible, cogent reasons and the delay is explained, always remember, in any court procedure, at any stage, unexplained delay is fatal. It will kill the case. Unexplained delay is fatal, it will kill the case. But a delay which can be cogently and credibly is explainable to realities and human nature, normal human nature, or the things that go on in the world as it is, then it is accepted by the court. Supposing you are given a notice to attend, a summons is served to you to attend court on a particular day at 10 am. While coming, there was a big cyclone. The entire transport got disrupted. So you could not come. Next time when you go, if you give this particular reason with proof, with a newspaper cutting or your own photos that you have taken, that is enough. The court will accept it. Okay. It will not try to arrest you and put behind bars and force you to give. Nothing of that sort. They accept. Court is also human. It understands what reality is there. So if the explanation is cogent, credible and delay is excused. In the case of Harbir Singh versus Sheshpal, Apex Court said delay in recording of statement of prosecution under 161 CRPC unless those witnesses were and could be available for examination when the IO visited the scene of occurrence, would cast a doubt about the prosecution case. So here the issue, so many times what happens is, all the people are there, but the IO will ask only, he will question only a few people whom he thinks are reliable, and he will leave out the fellow who was actually the eyewitness, the fellow who complained, telephoned, and fellow who actually was first in the scene. Such people he may leave out. And the second thing is, this fellow will give a statement, but some other fellow, more talkative and more verbose, he will give a much clearer view. So the police fellow may accept the other view because it is much more clearer and easy for him to note down than the version given by the first fellow who was actually on the scene. Such things may happen. So every delay in examining a witness is not fatal. Sometimes supposing you don't call the eyewitness in the witness box, that becomes fatal. If you juggle bring some other witness first and the eyewitness you bring somewhere in the middle, and that is not fatal. So because explanation has to be given why such sequencing is done. In Ganesh Bhagwan versus State of Maharashtra, the Supreme Court observed, though it is a well-seemed law that delay in recording statement of witness does not necessarily discredit the testimony, but if those witnesses were and could be available for examination when IO visited the scene of occurrence, then delay has occurred. It would cast a doubt on the prosecution's case. Next, so 161, 162 are over, 163 is not much of relevance. Then most important section is 164. 164 deals with confessions. It also covers admissions and then items of that nature. Because why it is important? It is important because this will provide a particular a good basis for the court to decide him to be guilty and punish him. So 164 statement while in court in the witness box is a very, very solid basis. It can be outside also. Let us see what are the differences. Confession means a formal statement that yes, I am guilty of the crime. Confession is not defined in Evidence Act. Confession includes admission, but admission is not confession. Every admission is not a confession. Confession means I have done it. Admission means this has happened. Okay? A sequence of events, a statement regarding a particular event is admission. Okay? But I have done this, I have committed this crime, and that is a confession. That means I am inviting the wrath, I am inviting punishment, I am inviting fine from the law. A confession either admits in terms of offence or at any rate substantially all the facts which constitute the offence. If a statement falls short of such plenary acknowledgement of guilt, it would not be a confession even though the statement is some incriminating fact. When taken along with other evidence tends to prove the guilt of the accused. Many times the witness will give you 80% admissions, but last 20%, that one word that I have done it, I have killed the person, I have used this instrument so that the other person will die, I have used this method knowing that the other person will die. That last word he will not say. Everything else he will say, but that last word he will keep quiet. So his admission is 80% of the facts required for proving him guilty. The rest of 20% you can get from all other circumstantial evidence. And if you get the 20% from all the circumstantial evidence and other witnesses, you can put 2 and 2 together and pronounce him as guilty. The person making it states something against himself, therefore, it should be made in surroundings which are free from suspicion. Otherwise, it violates the constitutional guarantee under Article 20, Clause 3 of self-incrimination. Nobody should be compelled to be a witness against himself. No self-incrimination is allowed. Direct acknowledgement of guilt should be regarded as a confession. In case Pakala Narayan Swamy versus Emperor, so I will also request you to, if you can have chance to read this case also, this judgment, Pakala Narayan Swamy versus Emperor. The question before the court was whether statements from which the guilt of the accused can be drawn amounts to confession or not. It was held a confession must either admit in terms of the offence or at any rate substantially all the elements of that offence which constitute the offence. Admission of gravely incriminating fact, even conclusively incriminating fact, is not in itself a confession. For example, an admission that the accused is the owner of and was in recent possession of a knife or a revolver, which finally caused the death, does not amount to confession. हाँ साहब मैंने खरीदा है, हाँ साहब इसी से खून हुआ है. But in between, I have killed, I have used that instrument to kill, that is missing, that is not a confession. He wasn't saying that I have purchased, he is also saying the same item has been used in this crime, but he is not saying that I have used it to commit the crime. So that linkage you cannot mentally, because we tend to make these mental connections and then finally pronounce him as guilty. That a judge should not do. Now, there are two types of confessions, inculpatory confessions and exculpatory confessions. Inculpatory means a confession which make him guilty, will make him guilty. Exculpatory means a confession which will prove that he is not guilty, which will add that he is not guilty. So, a confession, something wrong or which involves the accused of the guilt is inculpatory. Confession which absolves the accused of any guilt is therefore exculpatory. A confession may occur in any form. It may be the item itself, it may be a judicial confession, or it may be to anybody outside the court, among his friends, among his batchmates. It may amount to extrajudicial confession. That means a confession can be to a police or to the court. Confession can be before a magistrate. Confession can be to friends and relatives and other members. That is extrajudicial confession. Three types possible. It may even consist of a conversation with oneself. It may be produced in evidence if he is overheard by another. Supposing he kills somebody and goes to a bar and takes his drink. After some drinks he keeps on muttering, अरे मेरे से गलती हो गया, मैंने मार दिया, मेरे से गलती हो गया, मैंने मार दिया. This is heard by everybody else who is in the bar. If they come and give, this is overheard by others. That again amounts to extrajudicial confession. In Pakala Narayan Swami versus Emperor, accused admitted his guilt before police, refused to identify the accused before magistrate. The court held that it won't amount to confession and there was no direct admission of guilt by him. In Sahu versus State of UP, accused who was charged with murder of his daughter-in-law, with whom he was always quarrelling, was seen on the day of the murder going out of the home, saying words, I have finished her, and with her the daily, हर रोज का झिक-झिक मैंने खत्म कर दिया. हर रोज का झिक-झिक मैंने खत्म कर दिया. That's the word he said while going out, heard by everybody else. The statement was held to be a confession relevant to the evidence, for it is not necessary for the relevancy of a confession that it should be communicated to some other person. He went out while saying those words. He was not addressed to anybody in particular. Next, who can record confession statements? Section 164 of the Code gives the power to Metropolitan Magistrate or JMFC or JMSC to record confession and statement during the course of investigation under Chapter 12. During investigation or at any time afterwards before commencement of the trial. Magistrate may record confession, a statement made to him, but before doing so he is enjoined by subsection 2 therefore to explain to the person of Miranda rights. They are called Miranda rights. That means by whatever you are going to say, boss, please think over once more. Whatever you are going to say will be written down and will be used against you. So that decision has to be told to him. He has also should be informed that you have a right to keep silent. You don't have to make any confession. But if you choose to make out of your own volition, for whatever reason, it will be taken down, written down and used against you. So therefore you have to explain to the person, making it that he is not bound to make a confession, and that if he does so, it may be used as evidence against him. In the case of Kattar Singh versus Punjab, observe that 164 clause 2 of the code requires, as per rule 32 CR, criminal rules of practice, as soon as the accused intending to make a confession is produced and before he is told he would be allowed time for reflection, the magistrate should first explain him that it is not intended to make him an approver and that he is not bound to make a confession. He will not get any concession in punishment and warn him that if he does so, anything said by him will be taken down and it will be used as evidence against him, as evidence in relation to his complicity in the offence at the trial that is to follow. Compliance of the section 2 being mandatory and imperative, its non-compliance renders the confession inadmissible in evidence. That means, whenever the magistrate is taking down such confession, he should first mention, we should actually first ask the doctor saying that this man is in a fit condition to give a statement. Second, he himself should also mention that I have checked myself, I have put some questions to him and received some answers and I decided that he is in a fit mental position to give a statement. Then he has to write, I have explained to him that he is not necessary, his Miranda rights, that it is not necessary that he should confess, that whatever confession he makes will be written down and will be used against him. That, see, there is no pressure, there is no imperativeness that he should make a statement or a confession. So I have explained to him and he has agreed, he understood what I have said, and still he said, just to clear my mind, I want to make a confession. Hence I am writing down. So he has to make 2 introductory paragraphs and then write down. And it's also mentioned that no police officer is there anywhere within the hearing distance while I am taking my confession. That also he has to mention. So, compliance of subsection 2 being mandatory and imperative, the non-compliance renders the confession inadmissible in evidence. It was given under Shivappa versus Karnataka. Now, what is the object of recording 164 statement? Then why there is a need to record 164 statement at all? Okay, then there is already a statement under 162. So, the object of recording under 164 is twofold. One, to deter a witness from changing his version subsequently, to make it clear, to put it in so many words, to crystallize the sequence of events, to crystallize his mental position, to crystallize his mens rea, his intention, his knowledge, things like that. Two, to get over the immunity from prosecution in regard to information given by witness under section 162, because 162 and 161 are of no use to prosecution. So, that is the very good piece of information you find out, but you want it to be available for your trial. So, you can get a confession recorded by a magistrate under 164. The same thing that is there under 161 and 162 can be again put under 164 and a confession taken, duly signed by the magistrate. Then that will become admissible as evidence, substantial evidence in a court. Then your case will be strengthened. The other reason for recording statement of witness under 164 is to minimize the chances of changing the version by witness at trial under the fear of being involved in perjury. The object behind it, when during the course of investigation, police record the statement under 162, they cannot administer oath, but under 164 you can administer oath. Magistrate recording can administer oath and obtain his signature also in the statement. If a person signs a statement under oath, he becomes under a moral obligation and he will never turn hostile. So, evidence of a witness whose statement is recorded under 164 must be approached with caution. Then procedural safeguards. So, because so much of pressure is there, so much of value is there for this 164 statement, and the entire case can be either turned this way or that way because of 164, and the magistrate signature and the person's signature and things like that, lend lot of weight to it. So, Supreme Court has laid down a lot of procedural safeguards so that this provision is not misused. It says, magistrate shall record the confession in the manner provided under 281 for recording the examination of accused persons. It shall not only be signed by the magistrate but also by the accused himself. The magistrate shall also append a memorandum at the foot of the record laid down as per subsection 4 that if he has no jurisdiction to inquire or try the offence, a person, remember, a magistrate who is recording 164 confession should not be the magistrate who is trying. Both of them should not be the same person. If he has no jurisdiction to inquire or try the offence, he shall forward the confession so recorded to the magistrate where it is being tried. 164 CRPC and the rules and guidelines framed by High Court in this behalf must be complied with not only in form but also in essence. Where a confession is not recorded by magistrate in the manner prescribed under 164, then it is not admissible. The evidentiary value of 164. Evidentiary value of statement under 164 is that the statement cannot be treated as substantive evidence when the maker does not depose of such facts under oath during the trial. They should both tally. 164 should be the same as what he says before the court in the witness box on oath. So there should not be any contradiction again in that. If the contradiction is there, then this also will go through the window. Before acting on a confession made before judicial magistrate in terms of 164, the court must be satisfied that the procedural requirements of 2 to 4 are complied with. There are statutory safeguards to ensure confession is made voluntarily, underline the word voluntarily, by the accused, after being apprised of the implications of making such confession, after being told about his Miranda rights, after being told that he has a right to silence, after being told that under 20 clause 3 constitution he need not self-incriminate. The endeavour of court should be to apply its mind to the question whether accused was free from threat of duress or inducement. In the case Paramananda versus Assam, the confession would not ordinarily be considered a basic for conviction. Only on basis of confession you cannot give anybody a punishment, remember that. However, it is admissible and conviction may also be based if it is found truthful and voluntary and some corroboration is necessary. Confession which is not retracted at the time of trial, even accepted by the accused under 313 CRPC, can be fully relied upon. Conviction based thereon together with other circumstantial evidence is sustainable. Accused in his statement under 313 CRPC and during cross-examination never suggested that his statement under 164 is false. Allegation of the presence of police officer at the time of recording confession was without material. Always remember, I told you earlier that the magistrate should write in his confession statement that no police officer was present within the hearing distance while I am taking the confession. Important case laws. Let us see what are the different cases. AR 1953 Orissa. Statement committing magistrate is no doubt substantive evidence, but weight which should be attached to such evidence is a matter which is to be decided by the court according to the facts and circumstances. If a sessions judge for sufficient reason as to why he should accept the evidence taken before a committing magistrate in reference to that taken by himself, he should base his judgment upon such statement even if the evidence is not corroborated by any other independent witness. Next, in Bisipati Pradhan versus Orissa, Ram Kishan versus Harmit, and State versus Sriram Lohia. A statement of a witness under section 164 is not substantive evidence, but it is a formal statement made before an authority legally competent to investigate. Such a statement can be used either for corroboration of 157 of the Act or for contradiction under 145 of the Act. So what is the difference between these two, 164 statement and 161 162 statement? 161 and 162 statements cannot be used for corroboration, period. But 164 statement as given here can be used for corroboration. In Mohanty versus State of Maharashtra, the Act applies 145 only to cases where same person makes two contradictory statements, either in different proceedings or in two different stages of the same proceeding. In Bharat Singh versus Bhagirathi, if admission is duly proved, it can be used as a substantive evidence whether or not the witness was confronted with such admission or not when that witness came to witness box. Irrespective of when the witness came to witness box or whether it was presented to him and confronted of his both statements, either of the things happen or not, but still this becomes a substantive evidence. 164 becomes a substantive evidence. In Sitaram Patil versus Ramchandra Patil, even if the written admission is proved, it can be used as substantial evidence if the witness is so confronted with his previous admission in writing, as per 145. In case Balakram versus State of UP and Ramcharan versus UP, evidence of witness cannot be discarded merely because there are statements were recorded under 164. All that is required is a matter of caution, a careful analysis of the evidence. Next case, Tapandas versus Swastidas and Binay Kumar versus Bihar. If the witness disowns having made any statement which is inconsistent with his present stand in the witness box, then it could not be vitiated. The 164 cannot be vitiated until cross-examination proceeds to comply with the procedure prescribed under 145. In Tummalapalli versus AP, there is no rule of law that an earlier statement should be treated as correct and the subsequent is discarded. It can be either ways depending on what the court understands. State versus Qatar, Punjab. Statement under 164 is not a substantive evidence, but it can be used to corroborate or contradict. Both purposes are served. AR 1980 SC 628. The evidence of a witness in court whose statement has been previously recorded by a magistrate under 164 is always suspect, cannot be accepted as universally true and without any reservation. So you have to take it with a pinch of salt. That's what they say. IBB Rao versus State. When it is disclosed that a witness whose statement has been recorded under 164 was kept in police custody for several days and his whereabouts were not known, habeas corpus was also filed and was not disclosed to his relatives. The evidence tendered by that witness should not be relied upon. Okay, even if the magistrate signs that yes, he has given voluntarily before me, there was no police fellow, all such things. Ramchandra versus State of AR. When a witness whose statement under 164 was recorded was not sticking in his statement so recorded, the court should not rebuke him or do not threaten him that persecution of perjury will be liable for perjury. You should not say that. In Ram versus State, because you see, accused and witnesses are given the freedom in criminal trial to change their versions any number of times what they want. Because what the court says is that what is your duty is to find out the truth, not to hang the witness. Ram versus State. Unless witnesses resile from their statements recorded under 164, those statements cannot be deemed doubtful. 1981 Criminal Law Journal, NOC 138. Statement of a witness recorded under 164 of the court that the accused made before him extrajudicial confession of having killed the deceased constitutes substantial piece of evidence. Can be taken as substantial piece of evidence. In Haladar versus State, recording of statement under section 164 sometimes becomes very much necessary in the interest of a case if the police seeks to weaken or demolish a case or refusing to take steps for recording the statement of the witness at the earliest opportunity. Magistrate may record the statement of witness and de facto complainant under 164(5) of the code. In case T.S. John versus State, statement of deceased person recorded under 164 is not admissible under section 32(3) of the Evidence Act. Next case, statement of UP, State of UP versus Veer Singh, Shravan versus Maharashtra, Sushil Kumar versus MP. Dying declaration recorded with the belief that there is no chance of survival of the maker and the victim survived surprisingly, then such dying declaration becomes a 164 statement. 2004 Criminal Law Journal, Jharkhand. Magistrate cannot refuse to record the statement of informant under 164 on the ground that the case is under investigation. It is not open to magistrate say, I will not record. Then Adumbar versus State. If the witness turns hostile, his statement under 164, even if proved by examining the magistrate, cannot be used as substantial evidence. In Kanwarpal versus Haryana, evidence of a witness whose statement is recorded under 164 can be viewed with some initial distrust, but there is no rule of law that such evidence cannot be discarded. 1972 SCC 280. Statement under 164, even if proved, cannot be used as substantial evidence. Chaudhary Ranji versus State of Gujarat. Witness can only be contradicted under 145 of the code of his previous statement. Phulchand versus UP. Statement recorded under 164 cannot be relied upon for the purpose of conviction. Now, role of section 145 Indian Evidence Act regarding 161 and 164 statements. The aim is to give witness a chance of explaining the discrepancies. So when previous statement is to be proved as an admission, the statement as such should be put to witness. If the witness denied having given such a statement, it does not amount to any admission. If it is proved that he has given such statement, the attention of witness can be drawn on that statement also. Under 145 Act states cross-examination as to previous statements in writing. A witness may be cross-examined as to previous statements made by him in writing or reduced into writing and the relevant matters in question without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must be drawn before the writing can be proved and be called to those parts of it which are to be used for the purpose of contradicting him. Section 145 does not speak about as to which statement recorded under 162 or 164 is to be considered as a previous statement in writing. Both the statements recorded under 162 and 164 are therefore previous statements for the purpose of 145 Evidence Act. 145 consists of two parts. The first part enables the opponent to cross-examine a witness as to previous statement made by him in writing or reduced to writing without such writing being shown to him. Second part gives restriction on the opponent. If the opponent intended to contradict him by writing, his attention must be drawn before the writing can be proved. We call to those parts of it which are to be used for purpose of contradicting him. It will be needless to mention that while dealing with section 145, the case of Tahsildar Singh versus UP has been a milestone in judicial business. Without touching the ratio laid down in Tahsildar Singh, no criminal case can be accelerated. There can be no hard and fast rule as regards the compliance with the requirement of 145. All that is required is that witness must be treated fairly and be afforded a reasonable opportunity for explaining his contradiction after attention is drawn to him in a fair and reasonable manner. When prosecution examines a witness and asks him if he made certain statement before police or before magistrate under 164 and 162, the witness denies. It is the duty of prosecution to confront him with the statements written down and signed and get them marked as exhibits, so that witness might be afforded an opportunity either to explain his contradiction or to deny them. If the statement of the witness is too long and only one or two statements in it are to be used for contradiction, mere reading the whole lengthy statement may confuse the witness, and it would not be fair method of drawing attention of the witness. So it would be proper to put fact by fact of such statement, to say yes, no, please say. So, in conclusion, what will you say? Recording of statement under 161 and 164 CRPC plays a pivotal role. Purpose of contradiction between the evidence of a witness before court and the statement under 161 and 164 is primarily to shake the credit of the witness. It is only to put the court on guard, to scrutinize the evidence with greater care. It is the duty of all judicial officers to pay special attention to the provision of 164 and 164 of the Code with reference to 145 Evidence Act, so as to enable them to have clear notions about all relevant provisions in this regard. So this is all we have about the statements, confessions, admissions, contradictions, and all the case laws that are related to it. I will put this material in Telegram group. You can download from it and read. So, Swati, any questions? Otherwise, you can leave.
No, sir, not now.
Yeah. Thank you. You can leave.